Hello, and welcome to The Ethical Patent Lawyer, a primer on the ethics and regulation of patent prosecutors. My name is Emil Ali, and I'm a partner at McCabe & Ali LLP, where I focus my practice on helping lawyers understand their obligations under state and federal law. As a registered patent attorney, a significant focus of my practice involves advising lawyers and law firms on all aspects of the intersection of IP and ethics matters. My work includes counseling clients on lateral transitions, malpractice avoidance, providing expert opinion work and testimony, as well as respondents' defense work, i.e., representing lawyers before various bars and courts, including the USPTO's Office of Enrollment and Discipline. You can view my musings online on our blog, which is ipethicslaw.com. So today's CLE is geared towards registered patent practitioners, both agents and attorneys, as well as their support staff. I hope that this CLE will help you understand the obligations you have and include topics such as conflicts of interest, your candor requirements, the unauthorized practice of law, working with foreign associates, export control issues, and more. I want to begin by talking a little bit about the USPTO's regulatory powers. So just like many of you are members of various state bars, many of you are likely also members of the patent bar. So how did the patent bar come to be? Well, the USPTO has specific statutory authority to establish regulations governing the recognition and conduct of persons representing applicants or other parties before the USPTO. And that's under 35 U.S.C. 2B 2D. Another statute, 35 U.S.C. 32, allows the USPTO director to suspend or exclude any person, agent, or attorney who does not comply with the regulations established under 2B 2D. So, who is regulated and for what? In order to understand that, it's helpful to know the practitioner concept. Under 37 CFR Part 11, practitioner is defined as basically anyone who practices before the USPTO, whether it's a patent matter, a trademark matter, or any other matter, and that would include something like a FOIA request. This definition of practitioner also includes patent agents, as well as those who have been granted limited recognition. So those would be non-immigrant aliens, as well as law students. But who else is regulated? Well, under the definition of 37 CFR 11.5, practice before the office includes basically anyone who offers legal service. Under 11.5, this would include giving advice in contemplation of filing a patent or trademark application, or, of course, holding yourself as authorized to do so. So I want to pause for a moment here. Theoretically, under the USPTO's belief of their own regulation, a non-registered patent attorney, so basically a person not recognized to offer patent legal services, theoretically, if they offer to explain the difference between a design patent and a utility patent application, that could in fact be giving advice in contemplation of filing a patent application. So, what's the main question though? Do the USPTO rules trump state ethics rules? And this is an often confusing analysis. If we were to look at the model rules of professional conduct for guidance, and again, model rules are what they are. They're model rules. They form the basis of the ethics rules in all 50 states, as well as the District of Columbia, and actually at the USPTO as well. So if we look at those rules, most jurisdictions have adopted Rule 8.5, which is a choice of law provision. Unfortunately, the USPTO was not one of those jurisdictions. So when we're trying to understand what law applies or what set of ethics rules applies, we don't have the benefit of 8.5. Instead, we look to the preamble of 37 CFR 11.1. That provision states that nothing in this part, so 37 CFR Part 11, shall be construed to preempt the authority of each state to regulate the practice of law, except to the extent necessary for the United States Patent and Trademark Office to accomplish its federal objectives. So in other words, there is no field preemption. And this issue was in fact brought up all the way to the Federal Circuit and was heard in a matter called Kroll v. Finnerty back in 2001. So, to recap on the understanding of the USPTO's regulatory powers, as well as whether or not the USPTO rules trump state rules, the answer is maybe.